Today we've got some fantastic questions. It seems like I opened up Pandora's box. About a week ago I wrote a blog about Bank of America being sanctioned for violating the discharge injunction in an Orlando case. Judge Briskman, Arthur Briskman is the judge up there who wrote an opinion. Basically what happened is a person who filed bankruptcy up in Orlando surrendered their home and got a discharge. Pretty simple, standard Chapter 7 case. Well, after the discharge was entered, Bank of America just kept calling and calling and calling to the tune of, I think it was, I can't recall right offhand, but it was about 38 phone calls. So the attorney had sent, the attorney for the debtor had sent Bank of America one or two certified letters saying, hey, my client got a discharge, leave them alone. Kind of firing a shot across the bow saying, you know, don't do this. This is obviously in violation of a federal court order, the discharge. See, the discharge contains a permanent injunction for every creditor to stop or whatever action you're going to take to collect the debt. Don't do it, because there's an injunction out there which prevents creditors from taking any action to collect on a debt which has been included in the discharge. And this debt had clearly been included on the discharge. So ultimately, the letters didn't seem to work. And then what happens is they filed, the debtor had filed a motion for sanctions against Bank of America in the underlying case, meaning in their bankruptcy case, which either was closed or not. But a lot of people don't know, when a bankruptcy case is closed, you have to pay a fee to reopen it unless you're protecting the discharge. And when you're bringing an action against a creditor or in some way, shape, or form trying to protect the integrity of the discharge, then the filing fee is waived. So, you know, to bring this action, it really doesn't cost the debtor anything. The attorney incurs some attorney's fees, but really what you're seeking is sanctions in the form of damages against the individual creditor who's bringing or causing this action to be accrued. Now, you've got case law. Let's just hold off before we get into the Judge Briskman thing. But you've got case law all over the world, the nation, saying, here's what you need to do in order to set up a discharge violation. Basically, maybe you need to call the creditor, you need to do this. And that's just, in my opinion, it doesn't say that in the bankruptcy code. The bankruptcy code clearly sets forth an injunction which prohibits creditors. It doesn't say, a debtor's attorney, you have to send a letter. It doesn't say you have to be nice or you have to call the creditor and say, look guys, you're violating the discharge. It doesn't say that. Now, have I read opinions from judges around the nation that says, this is what you should have done or this is what you could have done to avoid this situation? Yes. But Judge Briskman, he kind of took the bull by the horns here. He set an evidentiary hearing and Bank of America just didn't show up, which I guess, to me, that's not a great idea. But what happened was the evidence brought forth at trial was already set forth in the record. So let's just look at it. When a person files bankruptcy, they're required to list all of their known creditors. I don't care if you owe somebody 10 cents, you're required to list that creditor. This way, the court gets your documents, meaning your petition for bankruptcy and your schedules, and they go ahead and they do the noticing. Everybody who's listed gets notified at the address you put on there. So in this case, Bank of America got notice, clearly got notice. And Judge Briskman said then he found that they got notice of the meeting of creditors, and then they got notice of the discharge, and they got notice of the final decree. And what did Bank of America do? Really ignored all that kind of sort of and just started the robo phone calls to the tune of about 38 phone calls. Now, we've handled cases where clients have gotten called a lot more than 38 times, despite the letter, despite the discharge, despite the bankruptcy and everything. But here what Judge Briskman did is he found the calls to be extremely egregious. And it worked out really well to the debtor's advantage, but the judge went ahead and he made some findings in his opinion which were really meaningful. Number one, he said in his opinion, and he cited some case law, I believe it was from the Ninth Circuit, don't quote me on that, that said he doesn't need medical testimony to find emotional damages when the violation was either intentional or this egregious. And that really means a lot, because if the person who's getting these phone calls is distraught, and many of them are because they're not supposed to be getting them. I mean, I tell my clients, look, nobody can collect this debt anymore. Well, guess what happens? Somebody starts collecting the debt. Well, now this person's looking at me saying, what are you going to do about this? You told me they can't call me. That's right, they can't. They're violating the law. Okay, what are you going to do about it? Because this is really driving me crazy. I shouldn't be getting these calls, right? No, you shouldn't. Well, why are they calling me then? The person's blood pressure starts going up, and it gets scary. Then you have the judge. Moving on, Judge Briskman also found that each call, all 38 of them, were a violation of the discharge injunction. That was huge because the question's always been is whether or not one phone call is its own violation or 38 phone calls creates the violation. Because you've got cases coming out of the FDCPA, which is the Fair Debt Collection Practices Act, which we talk about there, and the Fair Credit Collection Practices Act. And nobody really wants to go on and say, well, each call is its own violation subject to individual damages. And I think what Judge Briskman did here is he pushed the envelope just a little bit further. And I don't know if he was really upset about Bank of America's conduct in this case, or if he was just upset maybe they didn't show up for the hearing. But he really fine-tuned his opinion so that he can go ahead and really put the nail in the coffin, if you want, to Bank of America. He awarded that person $10,000 in damages plus $2,500 in attorney's fees for bringing the action. And again, your damages also include the amount of attorney's fees that you incur to bring the action. And the reason I think that's important is because an individual debtor should not have to incur attorney's fees to protect what they already have. In other words, the damages include attorney's fees so that, yeah, Bank of America, you've not only violated this and you should have not harassed this person, but now as a further sanction against you, we're going to make you pay their attorney's fees as well. And I really think this opinion is picking up steam because this is not an isolated incident. Bank of America has done this routinely. If you just Google Bank of America discharge violation, you're going to come up with numerous different opinions from across the state. I remember there's one in Texas, and I think there was one up north where attorneys had written about this. Now, that's not to say that that's an isolated incident either. There's, I'm sure, many other cases. I know we have several cases in our office right now as well. Fine. And a lot of them, or some of them, wind up in quiet settlements, meaning where the attorneys can't talk about them. So the people don't talk about them, the attorneys don't talk about them, and they can't blog about them, so they kind of get hidden or brushed under the rug. But what it's doing is developing a pattern and practice that Bank of America engages in. And right now we've got some great cases against some mortgage servicers who continue to call and harass after a person surrenders their home. And if you're watching the show, one individual client I'm thinking about right now, she knows who she is, and this one is so bad that they sold her home. In other words, she surrendered the home in the bankruptcy, she got her discharge. Not only did they finish the foreclosure, sold the home, now they're moving to vacate the foreclosure and unsell the home. I don't know how you do this, but now because they're unselling the home, the house is basically coming back into my client's name. And they think that gives them the right to harass the heck out of her. And obviously it doesn't, and we filed suit against them. So we're waiting to see where that one goes. But ammunition, like Judge Briskman's opinion, is just fantastic. Because now I can look and say to the creditor and say, hey, this is what Judge Briskman did in this case, and they only called 38 times. You've called my client 100 times, and she's told you she filed bankruptcy. She told you had an attorney. Oh, yeah, and by the way, you acknowledged 14 phone calls where she did say, yeah, I have an attorney. You go, yeah, I got it right here. But then again, another person calls from India, or another person calls from Afghanistan, or wherever they got these call centers, just randomly robo-calling the clients. So folks, the discharge, I'm glad this question came up because it was Lee from Pine Island who said, what's going on with the Judge Briskman case? Well, that case is over now, and I hate to say it, but Bank of America is going to have to pay that money unless they appeal it, and I don't know if they should do that because there's no record. They didn't show up for trial. It's kind of hard to appeal it and say, the judge was out of line when you didn't show up for trial and offer any evidence to mitigate those damages. Tell the judge you had a computer glitch or something. I mean, come up with some reason as to why you shouldn't have to pay this. But I think in this case, Bank of America is going to get pretty much smacked for it. Interestingly, a lot of attorneys picked up that blog that I wrote and were really interested in the case. And at the time I wrote it, I didn't have the opinion. I only had a hard copy of the opinion. I didn't have the link to it. So I got bombarded with emails saying, where'd this case come from? Where'd this case come from? So, I mean, again, in that case, Judge Briskman did a wonderful thing for debtors and debtors' attorneys, and actually creditors too, saying, don't do this, creditor. But debtors, if you do this, if this happens to you, and it's a harassment and it's all this stuff that's really bothering you, what you need to do is bring a motion for attorney's fees and for damages in my courtroom, and I will take care of it. Now again, you got to remember, folks, each bankruptcy judge is different. What happens in Judge Briskman's courtroom may not happen in a courtroom in the Southern District of Florida, the Northern District of Florida, Jacksonville, Tampa, Fort Myers, all different judges. And each judge may have handled this one differently. Obviously, Judge Briskman was a little ticked off that day at Bank of America and decided to sanction them accordingly to what he felt was the appropriate sanction for their conduct. But, you have a great judge, Judge Glenn, up in Jacksonville, momentary lapse there, he may have felt differently. A bankruptcy judge in New York may have felt differently and decided to rule accordingly. So really, from our perspective, it was a wonderful opinion, very well reasoned, very well written, showing exactly what happened and why he ruled the way he did.